Hello students, today let us learn the fourth chapter of your political science textbook, Understanding Laws. In the previous chapters, you read about different laws such as at what age a person can vote, the age at which Indian men and women can get married, etc. We know that in a democratic country like India, the parliamentary body is in charge of making different laws. In this chapter, we will try to understand whether these laws are applicable to everyone, how these new laws are formed, can a new law be controversial, what should be the citizens' reactions when these things happen. Suppose a top government official helps his daughter in hiding because she has been given a 5 years imprisonment for the crime that she has committed, which has been proved in the court. From this example, it is clear that the official's action is against the law because he has helped his daughter to escape the law. So, it is clear that he has tried to violate the law. In chapter 1, it was explained that while framing different laws, the members of the Constituent Assembly had agreed on this fact that in independent India, there shall be no arbitrary exercise of power. Hence, several provisions were instituted in the Constitution that would establish the law's rule. The most important among all the rules was that all the citizens of India were equal. Law does not discriminate between different citizens on the basis of their caste, religion, or gender. The rule of law means that no citizen is above the law and all these laws apply equally to every Indian citizen. Whether a person is wealthy, a government official, or even the country's president, everyone is equal before the law. If a person commits a crime or violates the law, it has specific punishment. There also exists a process through which the person's guilt can be established. However, the question is, has this system always been like this? In ancient times, there existed innumerable laws. Local laws often overlap each other. Different communities had different stages of autonomy as they administered these laws among themselves. In some cases, two persons belonging to different castes received different punishments for the same crime, while the upper caste person received lenient or soft punishment. Those belonging to the lower caste received harsher punishments. However, during the colonial period, this process began to change as the law started evolving or changing. It has always been stated that the rule of law was introduced in India by the British colonialists or the British government. However, the historians have always disputed this fact on several grounds because they do not agree with this fact that rule of law was established by the British because of two reasons. Those two reasons were the colonial rule was arbitrary or the colonial rule was based on individual judgment. Second one is Indian nationalists had an important role in developing British India's legal sphere. So we cannot say that the rule of law was introduced by the British because there are interference by the Indians in changing the law in India. The Sedition Act of 1870 was such that it continued to exist and was an example of arbitrariness by the Britishers. Any person who criticized or protested against the policy of the British, he could immediately get arrested without any trial. Soon, the Indian nationalists started opposing and criticizing the Britishers' arbitrary use of authority. The Indian nationalists demanded equality and wanted to change the aim of law from being some rules which were imposed upon the people to being an idea that promoted the aim of imparting justice to the people of the country, India. As the 19th century ended, the legal profession in India also began to emerge. They gained respect for Indians in the colonial courts. They started taking the help of law to defend the rights of fellow Indians. Even Indian judges had a greater role in the process of decision making inside the colonial courts. Hence, there existed several ways through which the Indians had started playing a major role in the evolution of the rule of law during the colonial rule in India. Once independent India adopted a constitution, this document served as a foundation on the basis of which the Indian lawmakers and elected representatives started making laws for India. Every year, these representatives pass many laws. They also make amendments or changes in the currently existing laws. In class 6, you might have studied about the Hindu Succession Amendment Act of 2005. It states that daughters, sons, as well as their mothers have a right to get an equal share in the family property. Apart from that, several new laws have been passed by the representatives. How do new laws come about? When a new law is being drafted, the parliament has a key role in the process. It takes place in different ways. Mostly, it has been observed that different groups of Indian societies raise their voice if the country needs a particular law. While making the laws, the lawmakers in the parliament need to be sensitive to the demands of the people. They should be responding in a positive way towards the needs of the people. For example, several lawmakers, students, and activists came together so that an act to prevent domestic violence could be formed. They submitted a draft to the Parliamentary Standing Committee, which in turn submitted its recommendations to the Lok Sabha and Rajya Sabha. Once the bill was passed in the two houses, that is Lok Sabha and Rajya Sabha, it was sent to the President. Finally, the Bill for Protection of Women Against Domestic Violence Act came into existence in 2005. What is this domestic violence? Domestic violence refers to any harm, injury or threat caused by the actions of an adult male, usually by a husband, against his wife. Injury can also be caused if a man abuses a woman emotionally or beats her physically. According to the Protection of Women from Domestic Violence Act 2005, the term domestic is extended to all those women who live or have lived under a shared household with that male member who causes the violence. The citizen's role is crucial or very important when the parliament is framing different concerns that the Indian citizens might have regarding the laws. When a law is being processed, at every stage the voice of the citizen is important, whether it is about establishing a new law or it being passed. The voice of the people can be heard through TV debates, newspaper editorials and reports, local meetings, radio broadcasts, etc. With the help of these, the parliament's work becomes more transparent and accessible to the people. Now let us find out what is the role of the citizens when an unpopular or controversial law is passed by the parliament. Unpopular and controversial laws. There have been certain situations where after the parliament passed a law, it became unpopular among the people. At times, even if a law is constitutionally valid and thereby legal, people may find it unacceptable and unpopular. They might feel that the intention behind it is harmful or unfair. Therefore, a group of people may come ahead to criticize the law, hold meetings regarding it, write against it in newspapers, report to TV channels, etc. In a democratic country like India, people can express their unwillingness to accept a law formed by the parliament which they think is repressive. If a large number of citizens feel that the lawmaking body has passed a wrong law, there arises a pressure on the parliament to change it. For example, according to the municipal laws, vending and street hawking is illegal in the space within municipal limits. Payments are made so that people can walk on them, especially when there is heavy traffic. However, even hawkers and vendors provide cheap services to millions in a city when they sell things in the pavements. It's a means of livelihood for them. Therefore, if a law is made which favors one group and ignores the others, the law will be regarded as being controversial. It can lead to a conflict. The people who think that such laws are not fair also have an option to approach the court, where the issue will be decided. The court has the power to modify or cancel a law which does not adhere to the Constitution or which does not follow the Constitution. So, we can conclude the chapter by saying that as a citizen, our duty is more than that of electing representatives to Parliament. Our duty begins when we carefully read the newspaper and watch the news to note how the MPs are performing and check if they are working for the welfare of the voters in their respective constituency or not. We need to criticize their actions whenever required. It is the enthusiasm, involvement and extent of the people which helps the parliamentary representatives to perform their duties properly. That's all the chapter. Now read the chapter well and make as many one-word questions and answers as possible and send that to my WhatsApp number before 5 o'clock today. Thank you for watching.